intentional crimes, and reckless crimes. The self-defense legal arguments are different for each. Then on the y-axis, the vertical axis here, I have individuals. So the top box reads aggressor. That's the person you're defending yourself against in a self-defense scenario. The bottom box is bystander. Someone you end up using force against, but you were not intending to use force against. This 2x2 matrix is what the court should have been applying in its analysis of its Commonwealth v. Fowlin is the case we'll be looking at. It's like fouling, but without the G, Fowlin. Because we need to do our legal analysis of the force used against the aggressor separately from any force that ends up being used against a bystander. So we have to ask, was the force against the aggressor intentional? And if it was, then we consider the self-defense argument, the justification, the confession and avoidance argument to justify that intentional use of force against the aggressor. Or we have to ask if the force against the aggressor was reckless. And then self-defense would be raised as an element negating defense. And we would have a different set of arguments and analysis. In the case of the bystander, of course, almost invariably, the use of force against the bystander is not intentional. That's pretty much inherent to the bystander scenario. But it may have been reckless, in which case we would need to look at the self-defense, legal defense, for recklessness with respect to the bystander. But the legal analysis with respect to the force against the aggressor and against the bystander are two distinct things. They have to be evaluated separately. Why? Because the use of force is what drives the underlying criminal charge. So imagine a scenario in which you're attacked by a guy charging at you with a machete. That's the aggressor. You intend to use force against him. You draw your pistol. You fire a shot. Maybe you fire a couple shots. One of the shots overpenetrates or one of the shots misses and ends up hitting a bystander and killing the bystander. So you end up killing both the aggressor who came at you with the machete and you end up killing a completely innocent bystander. Those are going to be two separate criminal charges. One would typically be maybe the prosecutor wants to test your claim of self-defense. So he says, well, the shooting of the aggressor intentionally, that was murder. And the killing of the bystander, that was involuntary manslaughter based on recklessness. So we have one intentional. We have a criminal charge based on intentional use of force and a criminal charge based on reckless use of force. For the aggressor, you intended to shoot, and the bystander unintentionally killed by your use of force. Those are two different criminal charges, and you'll raise a distinct legal defense to each of them. You could be guilty of one and not the other, or the other and not the one, or both or neither. But they are distinct legal analyses for each of those. One of the confusions the Pennsylvania Supreme Court runs into here is they want to come to the conclusion that if your use of force against the guy with the machete, your intentional use of defensive force, if that was lawful, then any bystander unintentionally killed by you, that killing also has to be lawful. That is incorrect. That could be true, but it's also possible that your killing of the aggressor who you intended to use force against was lawful, and your use of force against the bystander was unlawful, was reckless conduct. Because it has to be a distinct analysis for each. That's what the dissent doesn't like in this opinion, because the dissent is saying, listen, if you're saying that the use of force against the aggressor, if that's lawful self-defense, then an infinite number of other deaths resulting unintentionally also cannot carry legal liability. The dissent objects to that outcome. And I think the dissent is right to object to that outcome because I think it's the wrong analysis. Now, part of the difficulty with this case, there's a cliche in the law that bad facts make for bad law. So when courts have a complicated fact pattern and they do not have a well-disciplined and rigorous understanding of the legal doctrines to be applied, everything begins to become kind of a hot mess, because they're applying legal doctrines in an imperfect, sloppy way to underlying facts that are a little bit imperfect and sloppy too. Often the facts have not been determined by a jury, and it's not the role of judges to determine what ambiguous facts are proven or not proven. It's really up to a jury to do that. And we're going to see a bunch of that in this particular case. So because we don't have a crystal clear fact pattern, it kind of opens up the door, or I should say, it catalyzes the opportunity for sloppy legal reasoning by the state Supreme Court.